Concession.
Good. So we've got four very interesting talks coming up from people from a variety of backgrounds and countries, starting with David Bentley, who's worked as a defence barrister for quite a number of years. And so I'm looking forward to the criminal lawyer's perspective on probability and statistics. At least I think I am, David.
Thank you, Jane. Well, good afternoon, everyone. I'm sorry to interrupt your snooze after lunch. I'll try and keep it reasonably snappy. In court, we tend to call these afternoon slots the graveyard slot because we have to work harder to get the jury's attention. I think actually... Can everybody hear? Can you hear me right at the back? Good. Well, as Jane said, I think at the beginning of her presentation this morning, that she felt a bit of an interloper and she didn't do crime. Well, just a few words. I do crime. That's all I do. I'm a criminal barrister. As you've heard, I've been doing criminal cases for about 30 years. I'm also a QC, which means I tend to get the nastier cases, the murders and the serious sex crimes and so on. The only advantage from the point of view of today that gives me, I suppose, is that those are the cases that tend to feature the latest DNA techniques and so on, so that I've had some experience from the court end of seeing these new techniques come into play and how we've tried to deal with them. Now, can I say this straight away? This is not going to be a technical presentation. There's no slides. I scraped a pass in GCSE maths. I do not have any great knowledge of maths beyond that, other than what I've picked up. So I'm not going to try and illustrate anything I say with answers today or give you examples of suggestions how things can be dealt with. What I do want to do is highlight some of the issues with you so that you can at least use that in deciding or looking at ways to bring together the discipline of statistics and maths and the discipline I'm in, that of law. Now, of course, the theme for today is, I think it's the nature of questions arising in court that can be addressed via probability and statistical methods. Well, that's really a very simple question, because the only question I have in court is, can the prosecution prove the case against my client? And that's actually the only question that the lawyers, or if you're prosecuting, can you prove your case? So a jury are sure. So that's really the question that we're interested in court. And so any input from experts is really feeding into that question. Now, the other thing, of course, is that in the system we operate in England and Wales, anything halfway serious gets heard by a jury. And that's something we're very attached to. But that comes with certain caveats. Well, first of all, a jury's opinion is, of course, highly subjective. That's what juries are asked to do. A judge will say to a jury, when they're looking at a witness, you look at a witness, you decide what you make of them, you decide whether you believe them, whether you disbelieve them, whether they're reliable or not reliable. So actually, juries are being encouraged straight away to bring into play all the things scientists would say you shouldn't do, prejudice, bias, and so on. But that's what a jury trial is about. And if, as is happening increasingly, science is featuring in criminal trials, then it has to deal with that basic reality. I would suggest there's no pretense that a trial is a scientific exercise. Certainly if you're defending, you're not trying to establish the truth as a scientist might be trying to establish. What you're trying to do is, if you're defending, stop the prosecution proving their case, and if you're prosecuting, making sure that you can convince that jury. And of course, you're asking 12 lay people who have not been screened. In this country, you don't question them beforehand, so there's no, except on very limited grounds, but you can't find out what their expertise is. You might have a professor of statistics on your jury, but you're not going to know. Equally, you may have people with even less mathematical ability than I have, and that should worry most of you. Now, what are juries told by judges? Well, they're told to apply their common sense and experience of the world. That's the sort of thing juries are told. So that's the world that statistics has to come into. And then, of course, there's the verdict, because in any normal exercise, you put your arguments, someone makes a decision, and then the reasons are given, and you can say, well, you've got these reasons right or you've got them wrong. A jury trial, of course, is effectively a black box, because you feed all the information into the jury, but you're not allowed, if it's against the law, to ask the jury why they reached certain conclusions or how they agreed or what they agreed on. So the problem we also have here is you don't know. You've put all this incredibly interesting DNA evidence, for example, in front of the jury, but you don't know what they've accepted, what they've rejected, and in fact you'll never know. And that fits with the fact that historically criminal trials have just been concerned with questions of veracity and reliability. So, for example, in a sex offence case, the issue is consent. Was the complainant consenting? Are you sure? On that sort of issue. And that's usually one person's word against another. And I don't think anyone yet has developed a machine that can actually work out the correct answer, so we use a jury for that. Equally, I suppose if you look at a question of identification, someone picks someone out at an identification procedure. Again, the questions juries are going to ask themselves is this reliable? You can't really, some people might say you could, but you can't really apply a mathematical formula, at least not one that would be very welcome in the courts. So the courts are very clear that non-expert evidence, that sort of evidence, isn't to be given any sort of statistical underpinning. The case of Adams that's already been referred to, that in that case, in fact, there was DNA evidence, it's quite an old case now, relied on by the prosecution, quite an early stage, I think this was in 1997. And the defense in that case, I think, tried to introduce some sort of Bayesian calculation of probability to look at the other non-scientific evidence. And it ended up that the jury actually got instructions by the expert of how to sort of do this exercise. Well, it won't surprise you to know at the end of all that, the jury convicted, it went to the Court of Appeal, and the Court of Appeal gave a pretty withering judgment and said, and you've heard part of this already, Bayes was described as very complex and which jury are unlikely to understand fully or even more unlikely to apply accurately. And they said this: expert evidence should not be admitted to induce juries to attach mathematical values to probabilities arising from non-scientific evidence adduced at trial. So if it hasn't got a scientific underpinning, forget it if you're going to try and introduce probabilities and statistics. And then there's that case that I know a lot of people are very unhappy about, the case of T, which was about footwear marks comparison, where I think in that, if I remember the facts, the expert on the Crown called to compare footwear marks left at the scene of a crime or what have you, gave an evaluation of weight of evidence. I think didn't express it numerically, but gave strong support or whatever it was. But it turned out, I think this only emerged on the appeal, that was actually underpinned by some Bayesian calculations, and it was just slotting in the figures, and the Court of Appeal were not happy with that. In fact, what it seems to do is that was actually the lack of the data, because what the Court of Appeal are very keen on, some of you may say wrongly if you understand statistics, but if there's a very small database, for example, you've been looking at shoes, so I've looked at 500 pairs of shoes over the last year, so that gives me expertise, they'll say that's not enough. That's why the courts tend to like DNA, because it looks like these are big databases. I'm not sure anyone's yet pointed out that many of those databases are on incredibly limited parts of the population, but I don't understand enough about maths to know whether that's a problem or not. So the problem, it seems to me, comes about when scientific expert evidence is introduced into this evidential mix. And the question, of course, then becomes, if you're narrowing it down, how strong or otherwise is this piece of forensic evidence? Now, technically, forensic evidence is no different from other evidence. And what's paramount is the evidence that they get is robust, reliable, and, of course, comprehensible. The problem, as I say, is we will never know whether a jury have understood. All you'll know is whether they found someone guilty or not guilty, but that doesn't necessarily mean they understood what they were told. And in fact, a further complication for expert witnesses is this. Juries are specifically directed by the judge, of course, before they consider their verdicts. And one of the things they're directed is that although they've heard expert evidence, it's entirely a matter for them whether they accept or reject. So you can be the most esteemed person in the academic world and all other academics are deferring to you. But the reality is a jury, and that's something jealously guarded by the courts, the jury can say, we reject this evidence, and they don't have to explain why. But of course, juries are not generally going to be equipped to assess that sort of expert evidence. And that's indeed why the expert evidence becomes admissible, because it's only admissible if it's something outside a normal jury, a normal person's understanding. And obviously analysing DNA, for example, comes within that category. The problem for those of us involved in court is that this sort of evidence, and I'm going to look particularly at DNA, is often the decisive element in the prosecution case. And contrary to what some people may think, as soon as DNA is mentioned by the prosecution at the beginning of the case, the jury sit up. They're assuming immediately there's guilt there. And so it starts with actually almost a bit too much power. And the job sometimes of the defence is to try and actually point out that there are, as in any scientific endeavour, there are matters, there are weaknesses, there are things that can be pointed out. Now, as far as DNA is concerned, that's of course the main area where probability and statistical methods are used. And one of the big problems, which I know is something that's being considered by this project, is how do you communicate to an essentially lay jury what the strength is of the evidence. Now, you can give a random match probability if it's a single profile of DNA. If it's a mixture, you may be able to then give a likelihood ratio. And you can give sort of figures to juries. The question is, how do you express that in a way that they're actually going to understand? Is it useful to say to someone, the chances of this profile occurring randomly in the population, it matches your client, but the chance of it occurring randomly are 1 in a billion. How useful is that information? And I know that some people, and I think some people in this audience here, prefer actually to then use a verbal explanation, which in fact in many ways, as long as it could be standardized, is probably more sensible. So the problem, as I'm sure many of you that have looked at the area of DNA is concerned, comes with complex mixtures. Because for lawyers, anyone can understand if you've got a single strong profile from a crime scene, not difficult to see. You can see all the matching alleles or otherwise, and it's very easy to understand the power of that. The problem, as Alan Jameson was illustrating with his counters, is once you increase the number of possible contributors, it introduces all kinds of difficulties. And that's become so difficult that in fact the straight biologists or the forensic scientists have thrown their hands up in horror and said, I can't actually give you a statistic. And then they've gone to computer modeling, and you'll be aware obviously that there are a number now of computer models, some of which have been used in the courts, some in America, some here, some in New Zealand, and so on. Key ones, STR mix, true allele, like LTD, so on. There's a number of different programs used out there. And of course, these models all differ, because one of the problems from a lawyer's point of view is this. You can show jury, for example, you can say this is a match to someone's DNA in a single profile. You can show a jury graphically, well, there's the suspect profile that's come from the crime scene, and there's the profile of the defendant. That's not difficult. But the problem with these complex mixtures is effectively all that information has to be fed into, has to be coded, and then fed into a computer program. And that computer program has to make allowances for all the biological phenomena, drop in, drop out, and so on. And what will happen, and at least one person in the audience here had the experience of being taken to task on this, is the lawyers then try and find out, well, how does this work? How have you modeled this? Have you allowed for this? Have you allowed for that? And one of the difficulties is, of course, that by their very nature, models are attempts to replicate something or to get something accurate. And they change and they evolve. And one of the concerns I've always had as a practicing lawyer, because I see the result at the other end when I have to meet the parents of the 16-year-old that's just got life for murder, is understanding, well, how reliable, how much has it been tested, not whether it's good, whether it's potentially very promising, because all the programs are potentially extremely good. That the concern, which I'll come back to in a few minutes, is actually to what extent those are reliable. Well, why does this matter? Well, I'll quote the Lord Chief Justice in only a very short quote, in a lecture he gave to the association I belong to, the CBA, Criminal Bar Association, a couple of years ago. He said, in a significant number of cases, in particular the most serious cases, the credibility of the criminal justice system depends on the quality of the science underpinning the forensic evidence in order to preserve confidence in the experts and the evidence they present. So it's the quality of the science. Now, this technology, as I've already adverted to, is used principally in the most serious cases. And that matters because those are the cases where people will, if properly convicted, will get very, very long sentences, life, example, for murder. And in an adversarial system, obviously the job of the lawyers on either side is to present and then to try and deconstruct or challenge, or at least see what the flaws are in that evidence. So it's a good way of testing. That's as long as both sides have the right experts and are properly funded. But let's imagine in an ideal world, I'd say it's quite a good way of testing. The problem becomes that you have to start with the lawyers and the judges understanding what's going on before we get anywhere near the jury understanding, because if the person asking the questions or the judge deciding admissibility doesn't understand, then there's no chance for the jury. So there's clearly whatever does go before the jury must be something that can be properly understood, can be properly explained, and black boxes, as far as the science is concerned, won't do. And there is one particular type of software that, although it's been accepted in Northern Ireland, was actually rejected in a trial here, where in fact the code, the source code, is proprietary and has not been released. And although in America it's used a lot, it's not been allowed, as far as I'm aware, to be used in courts in England and Wales that it has in Ireland. So there are then, just to see the limitations of time, I just want to deal with a few practicalities of what happens with expert evidence, this sort of evidence in court, because there are two stages effectively. The first stage is the admissibility test, because if expert evidence is produced, and it will normally come from the prosecution, because they will normally be analysing a sample, for example, of DNA, then the first thing is it's got to be admissible. Now, mostly, and I would say in 9 cases out of 10, if not more, 99 out of 100, it'll go in by default because there's been no objection. If you don't object to evidence, it's served on you, it goes in. That's not a very healthy thing, because I think that the trouble is most of that has gone in by default because the person reading the report, and they may have had one of these streamlined reports that's been referred to, hasn't really understood the issue, thinks it's very strong evidence, and has advised the client accordingly. So often it doesn't get challenged. There are also, there's a criminal practice direction that has to be satisfied if you do challenge. You'll be pleased to hear at 10 to 2, I'm not going to give you a complete run through of that. But the key test set out in part of that is this. The court, this is the judge, must be satisfied there is a sufficiently reliable scientific basis for the evidence to be admitted. If there is, then the court leaves the opposing views to be tested before the jury. So there's got to be a sufficiently reliable scientific basis. Of course, what does that mean? Well, you go on to the next section, and that tells you factors the court may take into account. So here are some. In determining reliability of the expert evidence, the extent and quality of the data on which it's based, the validity of the methods, margins of uncertainty, whether it's been reviewed by others, peer-reviewed, the completeness of the information. I mean, fairly common sense things. But you can see it's all really there up for grabs. I'd argue that's a pretty low threshold, sufficiently reliable. That's all you have to get it in front of the jury. Of course, the jury then have to make their own assessment of it. How reliable are the statistics because we get given some very powerful statistics in reports, and how reliable are they? Well, I hope it's not unfair to say that in DNA and statistical evaluations, we know that mistakes can and inevitably will occur, not all the time. People obviously aren't trying to get it wrong, but it's in the nature of anything scientific that things have got wrong, someone pointed out, it's corrected. The problem is if you're someone that got convicted 5 years ago and you're in prison, most people have forgotten about your case now. You probably won't get funding to get some new expert to review your case. So really it matters very much that everything is right. Well, how have the courts approached it? I can only speak from my own experience, because not many of these cases have actually got to the appeal court. This sort of computerized evidence is coming in a lot, but again, it's been admitted and rejected by the courts on a fairly ad hoc basis. One case that again will be known about here, where in fact someone was accused, a young man was accused of murder, and there was a mixed profile of DNA on a knife blade. He was tried in fact 3 times. The first trial, the judge didn't allow in the computerized evidence, said it hadn't yet been sufficiently, didn't say this, but effectively said it hadn't been sufficiently road tested or validated. And certainly defense lawyers got very excited about that. He was in fact convicted because there was other evidence, but the Court of Appeal then overturned his conviction because the other evidence was wrong. So there was a second trial, and that same evidence then got in front of a different judge who heard the same challenge on the admissibility of the evidence, and this time decided, as he was entitled to do, to allow it to go in. And then what happened is that meant that the jury had the pleasure of hearing not only from David Balding here, but from Professor Dan Crane from the USA, from Professor Chakraborty, and I think even some graphs were somehow got into evidence from Larry Muller over in California. And the result of that second trial was that the jury couldn't decide, and the jury were hung, and so there was a second retrial or third trial. Same evidence, different jury, different outcome this time, jury convicted. Now, it's not for me to say, I don't have views as to whether my clients are guilty or not. It doesn't really matter. The question is, what's the evidence? Perfectly proper to convict on the evidence that was there. No problem about that, but the problem it presents and illustrates perhaps to this room here is you can put the same evidence in front of 2 different lay juries and get 2 different results. So if you think a trial is about getting accuracy, trials are not about accuracy. True allele, probably it would take me an hour to go on about that, and I'm not going to. I don't want to be sued either. Other models obviously developed. Well, what's the problem? Well, the problem I'd suggest, and I'm not obviously the expert on this, it's only what I've gleaned from reading reports, talking to other experts and so on, is that some of the key phenomena that will affect the statistic generated, such as drop in, drop out, they make a huge difference. You vary the perceived dropout rate. So if you're saying there's a lot of dropout in this, so there's a lot of gaps in this profile, then that can massively alter the statistic that's offered. So that has to be, as I understand it, modelled. Now, there's very good arguments for why it's been modelled in certain ways and it's modelled differently by different people. But the problem I have as a lawyer is knowing that it's all very well someone saying to me, well, I've looked at this, this is, we think, a really sensible way of modelling this. That can't actually be demonstrated to me, and I can't demonstrate that to a jury. So in a sense, we are having to take this science on trust because it's just too complicated. Because really, to understand these models, you've got to have the skills of an advanced statistician, you've got to understand computer science and how coding's done, and then you've got to understand molecular biology, you've got to understand how DNA degrades, why things drop out and so on, and how these random or stochastic effects happen. So it's little wonder, is it, that in the courts there haven't actually been that many challenges to this evidence because it's just too damn difficult. Well, I'm going to try and be a bit more positive in the couple of minutes that that remain to me. The real problem is making sure that, because these programs are here to stay, is making sure they're producing reliable and robust evidence. Obviously, there is a lot of peer reviewing going on, and I know that. I think my concern is that errors do come up. I noticed that recently in Australia, I think STR mix was being used there, and it found, I think the people that were programming it weren't properly trained or hadn't bought the manual or something. I'm not quite sure what the point was, but it turns out that 60 cases in, I think it was New South Wales, had generated unreliable or inaccurate likelihood ratios, and I think they had to issue 35 new expert statements to correct that, and that's fine. It got revised, and I suppose everyone was happy. Again, other issues have arisen. Just a few days ago, there's a case called People Against Hillary in New York, which I think was only reported about 3 or 4 days ago, where although the judge found that the courts have held that STR mix is something that can go in front of the jury, there, I think the New York lab that was providing the data weren't accredited for using that, and the judge has just ruled that out, and I think that's key evidence in an ongoing murder case. Well, it matters also for this reason, that usually in DNA cases, DNA is just part of the evidential jigsaw. So while you could say, yes, well, that's important, you've also got an eyewitness, or you've got a confession, or what have you, CCTV. However, recent Court of Appeal authorities, a case called FNC, made clear that a strong DNA match without any supporting evidence at all can found a case to answer. So you can be convicted, according to the Court of Appeal, on a DNA match alone, as long as it's a big enough statistic. So that puts a lot of responsibility on the statisticians, because usually it's been explained away to say, well, it doesn't matter, there'll always be some other evidence. But the case of FNC does suggest that, in fact, you can be convicted on your DNA alone. In that case, a man brushed up against a woman on the tube, left a rather unpleasant stain on the back of her clothing. She didn't see who it was. The man slipped away into the crowd. Her clothing was seized. 11 years later, although the DNA profile had been found, it didn't match anyone known. A man was arrested for something completely different. It matched his profile. He made no comment when he was interviewed by police. I think he didn't get to the stage where he was giving any evidence, and his lawyers made a submission of no case, so there wasn't enough evidence. Judge chucked it out, and what happened in that case was the Court of Appeal reinstated it, said no, the judge got it wrong there, that is enough. Well, I'm going to give myself another 1 minute if I may. No one's held up the 5 minutes yet, but oh, you have. I've not been looking that way. Use that. Oh, good, very good, thank you. shows how you can never rely on statistics. Thank you. So, really, in conclusion, I want to say this: that there are a number of, I think, potentially ways forward. I think transparency is really important. I know that there are real efforts with some of these computerized systems, that it's all out there, that if you can get the right expert defending, you can get everything looked at. No one's saying, no, you can't see this. And I commend that. That's very good. Validation, well, that's part of the admissibility test. My only concern about that, and this really comes probably to funding, is that a lot of this now is run by private firms. Now, they will do their own evaluations, and I'm not saying they're not doing them properly, but there's a very strong case, I think, for independent evaluation. Now, there is a forensic science regulator. She has a DNA analyst specialist group that advises her, and there are a lot of very good experts on that group. But what they issue, their codes of practice are advisory, they don't have statutory force. Education is clearly essential. That, again, is being looked at. There are guides. There are 4 guides that were issued from 2010 up to about a year ago from the Royal Statistical Society. They're very good, but they're very long, and the reality is they're not going to be read by very many lawyers who are busy reading the evidence in their cases, and they're going to be read by even fewer juries. And for juries, perhaps the only optimistic point is that there are primers being produced, announced in February of this year, and that's going to start with DNA. So although I've got other things I could bore you with this afternoon, that's I think as far as I'm going to take it. Thank you very much for listening. I hope it was helpful.
If anybody has a question while Professor Cheryl Thomas comes up and gets wired up, that's fine. Norman?
In the third trial,
Yeah.
in that case,
Yeah.
were the same experts?
Are we still on?
You mentioned the names of 4 experts. Was it the same experts presenting evidence?
Yeah, we did use the same experts, did you?
Okay.
Yeah, we did. Although I think
Third was the same as the second, but not the first.
yeah.
Mueller was in the first.
Mueller was in the first, but in fact the first we didn't really have to get stuck into it.
Are you ready to go? Good.
Okay.